judgment in the matter of litigation of UK, SK, MIK and MAK children by their litigation friend EK and the GRB.
This is an appeal from an interim order of the Upper Tribunal requiring the Home Secretary to grant admission to this country to two of the claimants, referred to as EK and SK, who are present in France, so that they can join their two young children, MAK and MIK, who are in this country. The full story and the reasons for our decision appear in the judgments which we are now handing down, but I give this brief summary for the purposes of the press or other interested persons in court. The family are from Turkey. They are of Kurdish ethnicity, and the father claims that he faces persecution in Turkey because of his political activities. They came to Europe earlier this year in order to seek asylum. They travelled through Belgium and France, but they did not seek asylum in either of those countries. Instead, they made arrangements with people smugglers to cross the Channel from France in a small boat on the 19th of July. As a result of a violent incident while they were embarking, the boat left with the two children, but the parents were left behind. On arrival, the children were placed by Kent County Council with foster carers. They have been living with them since. They are being extremely well looked after, and they speak to their parents daily by phone, but the continued separation is very distressing, and obviously both they and their parents are anxious to be reunited as a family. The underlying dispute in this case is whether the family should be reunited in this country and be given the opportunity to claim asylum here, as the parents wish, or in France, as the Home Secretary argues. The reason why the Home Secretary believes that the family should be reunited in France and claim asylum there is that she is very concerned that if people smugglers get the message that if children arrive here unaccompanied on small boats, their parents will automatically be brought here to join them, they will place more children in boats without their parents at great risk to their lives and welfare. Her evidence is that that concern is shared by the French government and that plans to enable reunification in France are well advanced. The parents argue that the separation has gone on too long already and is seriously harmful to the children, and that it constitutes a breach of their rights under the European Convention of Human Rights. We allow the Home Secretary's appeal on the basis that her concerns about the dangerous precedent of allowing reunification in this country were justified, and that she was entitled to more time to pursue the plans for reunification in France. There are ongoing proceedings in the Family Division of the High Court, in which the question of what is best for the children will be further considered in the new year. I emphasise that that is only a summary of our reasons. The authoritative version appears in our judgments, which will appear on the National Archives website. I should also emphasise that an order is in place which prevents the publication of the identities of the children or the parents, or of any information which enables them to be identified. Breach of that order may be punishable as a contempt of court. Now, Mr. Anderson, Mr. Kilroy, you received a draft about an hour ago, so you knew what the effect was going to be. There are now in court copies in hand-down format, which are identical in terms of text. We would be that is on a subject to editorial corrections basis, which means that although it will go on the National Archives website as soon as possible, we will make any editorial changes that occur to us or that are suggested by either of you as soon as possible. I mean, ideally this afternoon, but that may not be practicable. We have already noticed a couple of errors in the title, which I'll mention now so that you don't need to tell us about them. One is that Mr. Lane has been put down as representing the respondents rather than the appellant. That will be changed. The appellant is, I notice, in the plural and the respondent in the singular, which is the wrong way round. And the government legal department should be referred to as the Treasury Solicitor in this context. Those are all tiny matters, but I mention them now to save you pointing them out to us. But if you could, as soon as possible, draw our attention to any other errors, we would be grateful. Now, consequential matters, if any.
My Lord, thank you very much. My Lord, I think from the Secretary of State's perspective, the only consequential matter would be in relation to costs.
What are you asking for?
In relation to which she would seek her costs subject to the usual protection for a legally aided party, the respondents being legally aided. However, I understand from my learned friend that there's a request for additional time to consider consequential matters, which I don't yet have any specific instructions.
Well, let's hear what it is. So yes, so formally that would be costs of the appeal to be assessed on the standard basis. Then I forget now what the normal formula is, but effectively, they won't get their costs. The Secretary of State won't get her costs, except in exceptional circumstances.
Effectively, the usual formula would provide that the Secretary of State would need to have the leave of the court.
Yes, right. In practice, sorry, I should know all this, but assessment doesn't even proceed in those circumstances.
My Lord, or ordinarily not. No.
Very well.
It can sometimes become relevant if there are other cost orders in different.
Yeah, I can see how. No, of course I can see. But anyway, that's what you're asking for, right?
My Lord, what I'd suggested to my learned friend was that so that we have an opportunity to take instructions, which I haven't had a chance to do in relation to appeal, that we postpone the issue of costs and application for permission to appeal for 14 days into the new year.
Well, that's. I'm not necessarily seeking to dissuade you from that. The purpose of letting you know an hour in advance was so that hopefully you would be able to take instructions. I appreciate, of course, that an hour is only an hour, and I don't obviously know what communications are like with EK and SK, but I thought the decisions that need to be made are fairly straightforward. You really don't feel in a position to pursue them now?
Well, my Lord, it's a legally aided case, so ordinarily one has to advise on merits.
Yes, of course.
So, and there are specific rules in relation to appeals.
No, I don't want to. You will know much better than what the complexities are.
Yes.
There is obviously an advantage from everyone's point of view in dealing with them today if we can, but you just don't think that's practicable.
Well, I haven't got instructions.
Yeah.
I mean, I think it wasn't in fact an hour ago. It was a little under an hour ago.
Well, I'm sorry.
We were all en route.
No, I was not.
I haven't even had a chance to speak to my instructing
Yes,
solicitor.
I'm sorry. We should. Well, the answer is. You can imagine it's been challenging to get the judgment out, so it wasn't possible to get it to you earlier. But I'm sorry we didn't. No, you weren't complaining, and I wasn't criticising you. Very well. We might just rise for a moment and see whether we can suggest something, but let's see. No.
is Alexander Lang here, but not in the one that was circulated. Yeah, because he wasn't here, was he? He wasn't here.
He's not on this. He's not on my.
Oh, on my draft, he's on it. He's with the respondents.
Yeah.
Yeah, he's definitely not on the electronic copy. But also, we haven't included people who weren't at the hearing, so I guess we can just either we'll add everybody. Anyway, we can just
We can sort that. I'm sure we can sort that.
just sort it out. It's just odd because he wasn't on the electronic.
He wasn't the outro. I mean, I'll maybe just flag that just in case it's a different.
That's what I was
Yeah.
thinking.
In
Is
case it's a
the
different
issue
It
is
looks like there's a different version.
that may have different
I
things
think
to
we
correct.
send something else, so we don't actually know if we're correcting the one that's their finance
Yeah.
version. So we do need to deal with that.
That would be annoying.
Yeah. That would be annoying.
Yes, I suppose that is the most important point, is that we now don't know which one we've got online.
Exactly.
Oh, look, there's been live stream.
Court rise.
Well, we're sympathetic to your difficulties, Ms. Kilroy, and of course we're not going to ask you to make submissions you haven't got instructions to make. The only thing we can offer, if you think this is realistically likely to make a difference, is we could sit again at 3. Are you likely to be in a position to have instructions by that time?
Well, it looks as if we may be able to get hold of them by then. I mean, I'm so sorry, I should be
No,
standing up.
don't worry.
I'm just wondering whether, I mean, from our point of view, it would be ordinarily, I would advise, from a legal aid point of view as well. So I'm just wondering why we can't have until what I discussed.
No,
with
you
the
can.
friend.
If you don't want it, we're not pressing this on you.
No.
We wondered,
Yes.
but only wondered, whether you would want to make any applications this afternoon, and it was only the pressure of having had only an hour rather than 3 hours that made the difference. If it's not really that, and you we're very happy to give you the 14 days you want. Was it 14 days?
Well, in fact, what we discussed was so that because we thought we might be able to agree in order on other consequences.
Yes,
for
I thought
example,
the cost thing I
until
can't.
well, I will be making
I
some
see.
arguments on costs, but it's the 7th of what we thought was the 7th of January. That's what we discussed between us. Although my learned friend doesn't have instructions, because that would give us time into the new year.
Look, it was merely to give you an opportunity.
for a
If it's
swift-
one which, for perfectly good reasons, you don't you would feel you don't want to take up, and I'm not criticising you, we'll await your submissions on paper.
And what that would require is to formally adjourn this hearing for them. It's McDonald and Rose, my lord. I'm sure you're aware of.
Well, McDonald Rose doesn't apply. We're talking about the Supreme Court. Doesn't apply to them. The Supreme Court rule now.
Yes.
I had to look at this recently, so I can. Is that you have 28 days from the refusal of permission to appeal in this court. That you didn't used to be the rule, but it is now. At least I hope it is. Yes.
No, I understand that.
So we won't have refused permission to appeal until some date after the 7th of January. So we don't need to adjourn anything.
Oh, it was really whether you were still you were functus if you handed down today without adjourning. But if
No. McDonnell Rose is I can say this with confidence since I
Yes.
wrote it, is a difficult judgment. My only excuse being that it's trying to make sense of a number of other difficult judgments. But I don't see it has any application in this situation.
In this situation. Well, I'm grateful, my lord. I may have
So all we need to do is simply say appeal allowed, order of the 30th of October, and indeed Upper Tribunal Judge Hurst's order set aside. Both parties to submit an agreed order or representations on matters which are not agreed by 7th of January to be dealt with on paper unless otherwise directed. Can you, Mr. Anderson, just produce a draft this afternoon along those lines?
My lord, yes.
And we'll get that order out today.
And I should perhaps flag now, although I don't have specific instructions on it, I suspect that my client would welcome an opportunity to respond to any application for permission to appeal if one is made. I'm not necessarily suggesting the court should say anything further in relation to that now.
Well, I don't think we need. Frankly, the way this usually goes is that, and the most sensible way of dealing with it is we look at the application. If we are minded to grant it or think there's a realistic chance we might grant it, then we will ask for submissions from the respondents to try and dissuade us. As you know, it's not very common, although obviously each case is different, for us to grant permission. The Supreme Court prefer to make those decisions for themselves, and it's often a waste of costs for the respondents to put in submissions. So what I suggest you do is wait and see whether we want submissions from you. We may in this case, but I wouldn't do them in advance.
I'm very grateful, my lord. My lord, can I also just flag one matter with you, which is simply that the version of the judgment that's been circulated on paper is I think, different from the version that we received electronically.
I hope not in substance, so in format.
I don't know that I don't think that it is in substance necessarily, my lord, although I've not yet gone through it. It's just that you'd flagged earlier the issue with regards to the placement of Mr. Lang's name. In the electronic version that was circulated earlier, Mr. Lang doesn't appear on the front page at all.
Yes, that was the change that I was drawing your attention to.
Oh, I'm sorry.
Well, okay, I didn't quite spell it out. He was omitted altogether. You're quite right. We had an email from him saying that he shouldn't be, and I asked my clerk to put him in, and she won't mind my saying so. She put him in the wrong place. That's how it happened.
Thank you, my lord. If it's otherwise,
Thank you all very much.